Good morning, everybody. Thank you for taking an hour out of your day to join me. My name is Amber Hines, and today we're going to be talking about planning for a married couple when both spouses are in the nursing home at the same time. If you have any questions on today's webinar, feel free to post those in the questions tab of the GoToWebinar dashboard. And also, if you're interested in a copy of the handouts from today's presentation, you can find those in the handouts portion as well. Again, my name is Amber Hines, and I have been doing Medicaid compliant annuities for the last 15 years and working with elder law and estate planning attorneys across the country to service Medicaid compliant annuities. I am insurance licensed in all states, and I hold a Series 65 license with FINRA. And I created Ashper to assist attorneys and advisors with both pre-planning solutions, which include hybrid long-term care insurance, as well as crisis planning solutions, which often involves Medicaid compliant annuities. We offer complimentary case analysis, so we can help to determine the optimal amount that would go into an annuity, the appropriate annuity term, and which assets should be annuitized for your clients. We offer assistance from beginning to the end of the case, so we're able to provide quotes as well as assistance with the annuity funding, especially if you have clients that have existing IRA accounts or deferred annuities that we're trying to initiate a 1035 exchange. Those are all services that we're able to assist with. And then also, if you have a client that purchases a Medicaid compliant annuity that would pass away during the annuity term, we offer assistance with contacting the state Medicaid agency to see if they provided any Medicaid benefits and help settle out the death claim process as well. We do only work with A-rated insurance carriers when we are looking at Medicaid compliant annuities for your clients, and often when comparing our fees, assuming we have to charge a fee, our fees are often less than our competitors for a Medicaid compliant annuity that would be offered from an A-rated insurance carrier. So when we're talking about a case where we have both spouses that are in a nursing home and they're both applying for Medicaid at the same time, both spouses are going to be referred to as a Medicaid applicant or the institutionalized person. We do not have a community spouse in this type of situation. Therefore, we are not looking at the spousal impoverishment rules where it would generally allow for a community spouse to keep around 130,000 in assets when we have a community spouse. So this is going to be a different type of situation when both spouses are in a facility and they're both trying to apply for Medicaid at the same time. We would have to look at the income and the asset limitation for a married couple where both spouses are going to apply for Medicaid at the same time. So each spouse's total income is going to have to be less than what their cost of care is. So if each spouse is being charged a different amount by the facility because one spouse's care needs are greater than the other, that's something that we would need to take into consideration and compare what the cost of care is for each spouse and make sure that their total income is going to be less than what they're actually being charged by the facility. There is an exception to this rule if you live in a state that is considered to be an income cap state. Then any income that is going to be over the 2382 is going to be considered, would need to flow through the Miller Trust in order for that person to meet the income limitation. So like I said, the income limitation does apply to each spouse, so we need to take into consideration the cost and the income of each spouse. And then when we look at the asset limitation for a married couple, generally each spouse is going to be able to keep around $2,000 in assets. This does vary by state. So you can go on our website and find what the asset limitation is for a situation where you have both spouses in a facility. For example, states like Ohio and New Jersey, the asset limitation is going to be $3,000 total between the couple, whereas Illinois is a state that allows for $2,000 per spouse. So that would be a total of $4,000 as the asset limitation in a state like Illinois. Why is this type of planning, when we have both spouses that are needing care, more complicated than the community spouse planning? I kind of already talked about the fact that in this case, we do not have a community spouse, so the spousal impoverishment rules are not going to apply. So in this case, since we don't have a community spouse that we can transfer most of the assets to, we're not able to achieve immediate Medicaid eligibility like we would be able to in a traditional community spouse type annuity plan. The second reason why this planning is more complicated is because the couple is going to be entitled to a very limited amount of assets. In a traditional community spouse plan, it's usually around $130,000 that the community spouse can keep. But in this case, like we just talked about, the couple is going to be very limited in the amount of liquid assets they can keep. It's going to be around $2,000 per person or $4,000 total in many states. And then finally, the third reason why the planning is going to be more complicated is because if a gift or a transfer is made by one spouse, most state Medicaid agencies are going to split or divide the penalty period equally between the two spouses. The Medicaid planning opportunities that involve a Medicaid compliant annuity when both spouses are applying for Medicaid at the same time is going to be a gift and annuity plan, which is what most of today's webinar is going to be focused on. So in this case, we have a married couple, Robert and Mary. Robert is 80 years of age. He has Parkinson's and resides in a nursing home. He has monthly income of $2,000 per month, and his monthly nursing home bill is $10,000 per month. Mary is Robert's wife, and she is 75 years of age. She is ill and frail from caring for Robert for many years. She also resides in a nursing home. Her monthly income is $1,000 per month, and her nursing home bill is the same as Robert's at $10,000 per month. The couple's family feels that since they are now both in a nursing home facility, that they could live for another 5 years in this sort of environment, and they have $300,000 of non-IRA bank accounts. First, we're going to determine what the monthly income shortfall or deficit is for each spouse. We see here that Robert is paying $10,000 per month for his nursing home bill, and he has monthly income of $2,000. So he has a shortfall each month of $8,000. Whereas Mary has a nursing home bill of $10,000 per month. Her income is $1,000, leaving her shortfall at $9,000 per month. And this is the income limitation that I was talking about, as far as making sure that we're taking into consideration each individual's nursing home cost as well as their individual income amounts to determine what they're going to be short each month. When we look at their combined monthly income shortfall or their combined deficit, we know that each spouse is paying $10,000 per month, so they have a total charge of $20,000 per month, and their total income is going to be $3,000 per month when we add the $2,000 from Robert's side and $1,000 from Mary's side to get $3,000 of total income. Therefore, on a monthly basis, they are short $17,000 per month, or this is what their monthly shortfall or deficit is going to be. If the couple does no planning at all and they have a monthly shortfall of $17,000 per month, they had $300,000 of liquid assets. If you divide that 300,000 by the 17,000 that they are going to be using on a monthly basis, their total life savings are only going to last them around 17 months or just over 1 year. We talked about the fact that Robert and Mary's family anticipates them living for many more years. So doing nothing and just depleting the couple's assets is not really a great option in this case. So we're going to look at different planning opportunities that we can do to preserve at least a portion of the 300,000 that they have. We look at the gift and annuity plan. The goals of the gifting plan is to allow a married couple where both spouses are in a facility to make an immediate wealth transfer or a gift to their intended beneficiaries, and also allow for both applicants to qualify for Medicaid at the end of an ineligibility or a penalty period that is associated to making the gift. As a result of the Deficit Reduction Act of 2005, we know that in order for Medicaid to start a penalty period, both applicants in this case must be income and asset eligible. So we can think about the total $300,000 that this couple has in assets as going into 3 different buckets of money. Each applicant first is going to keep around $2,000 or less of resources. This again is going to depend on the state. If it's a total of $4,000 or $3,000 that the applicants are able to keep, that is going to be considered their resource allowance. They're also going to make a gift with another portion of the money. And then finally, each applicant would purchase a Medicaid compliant annuity as the third bucket of money. So step 1 of the gifting plan would be to determine the monthly income shortfall, which we've already done. We've determined that their total shortfall between the couple is going to be $17,000 on a monthly basis. The second step is going to be to determine what the burn rate is, or how much money the couple is short, as well as taking into consideration what the state Medicaid divisor amount is. And we are going to add these 2 numbers together. So the monthly income shortfall of $17,000 is added to this state's Medicaid divisor of, in this case, it's going to be $10,730 for an individual. We doubled that number in this case since we are dealing with a husband and wife where both spouses are applying for benefits at the same time. So that double divisor amount is going to equal $21,460 per month, so that the burn rate is going to be $38,460.20 on a monthly basis. What is the divisor and where do we find it? So Medicaid is going to calculate a penalty or ineligibility period by dividing the total amount that is transferred or gifted by the penalty divisor. The penalty divisor is a number that is published by Medicaid, and it is considered to be the average cost of 1 month in a nursing home in your state. And so this number does vary depending on the state. If we're looking at a state like Pennsylvania or New Jersey, the penalty divisor is going to be around $10,000 or $11,000 a month. Whereas a state like Georgia, where I'm at, the divisor is going to be $6,000 a month or so. So the cost of care is going to really drive what the divisor amount is in your state. You can find the divisor either in your state Medicaid manual, or we have those published on our website as well. In this case, the divisor amount was doubled because, again, we have 2 Medicaid applicants that would be applying for Medicaid at the same time. And in most states, Medicaid is going to split the penalty period equally between each spouse. So we typically are going to look for language in a Medicaid manual that talks about if both spouses are applying at the same time, then the penalty period is going to be divided equally between the 2 spouses. The next step would be to determine what the actual penalty period will be. We can determine the length of the plan by dividing the spend down amount of $300,000 by the burn rate that we just calculated at $38,460 per month. And we determine that the term of this plan is going to be 7.8 months, or in this case, we're going to round that up to an 8-month term. The gift amount would be determined by taking the term of the plan, 8 months, and multiplying that by the divisor, double the divisor of $21,460 per month. And we determined that the total gift amount is going to be $171,681.60. We then determine how much would be able to go into the annuity, and this is going to be the total amount that will go into an annuity for each spouse. We determine that by taking the spend down amount of $300,000 and subtracting out the gift amount of $171,000 to determine that the annuity amount equals $128,318. Like I said, the annuity total of $128,318 is going to be the total amount that can be used to purchase an annuity for Robert and Mary individually. Each spouse in this case would need to purchase their own Medicaid compliant annuity so that we're able to meet the income requirements and keep their total income under the cost of care. It's not possible at this point to do a jointly owned Medicaid compliant annuity where half of the income from the annuity would be split equally between the 2 spouses. Therefore, each spouse would purchase their own annuity based on what their own income needs are, based on how much income they actually need. So how we decide how much of the $128,000 is used to purchase an annuity for each spouse, we have to refer back to the individual monthly income shortfalls that we initially talked about. You recall that Robert's monthly income was $2,000, whereas Mary's monthly income was $1,000 per month. So Robert has a greater shortfall, Mary has a greater shortfall amount than what Robert does, which means that we can generate more income for Mary on a monthly basis than we would be able to for Robert. So of the $128,000 that would be used to purchase the annuity, we would put $60,000 into an annuity for Robert, and we would structure that over an 8-month term so that the monthly payment on his annuity is going to be $7,510 per month. Mary is going to purchase an annuity for the remaining amount of $68,318. Again, her annuity is going to be structured over an 8-month term so that the monthly payment on her annuity is going to be $8,550 per month. You see that the total payout on both annuities is going to be slightly greater than what is invested into the contract, and that is going to just represent a small amount of interest that is paid on each of these annuities. And the annuity term is going to be structured for a whole number of months. We couldn't do an annuity for 7.5 months or a partial month annuity. So the annuity term is going to be structured over an 8-month time frame, and you're seeing the monthly payouts on the screen here. During the 8-month penalty period, Robert's total monthly income is going to consist of his Social Security income at $2,000 plus his annuity income at $7,510, so that his total income on a monthly basis is $9,510. Robert is currently spending $10,000 a month on his care. When we subtract out what his total income is at $9,510, we see that he has a monthly income shortfall of around $490 per month. When we add Mary's monthly income from Social Security at $1,000 plus her annuity income at $8,550 per month, we see that the total income for her is $9,550 per month. Mary also was spending $10,000 per month on her care. When we subtract out her total monthly income, we see that her monthly shortfall, when we take into consideration all of her income sources, is $450 per month. Many people ask the question of why it's necessary to create a monthly income shortfall for a gifting plan, and it really stems from the otherwise eligible criteria for Medicaid. So we have to be sure in this case that both Medicaid applicants' total income is less than their individual cost of care, that they are spent down to the allowable resource limitations, and then also that a Medicaid application is being made, so that we are establishing that the person is actually in need of Medicaid starting a penalty period. So we cannot create exactly the amount of income that would be necessary to pay for each one of these individuals' nursing home costs, which is why there is going to be a shortfall on a monthly basis for each spouse that would be applying for Medicaid. The economic results of doing the gift and annuity strategy in this case is that we were able to make an immediate wealth transfer or a gift of $171,681. And this is going to represent over 50% of the $300,000 that this couple had in resources. Robert and Mary are both going to be ineligible for Medicaid for an 8-month period, which is the private pay or penalty period for each spouse. Robert, when we take into consideration his Social Security and his annuity payments, he had monthly income of $9,510 per month during the penalty period. So his shortfall again is going to be $490 per month. He is going to become eligible for Medicaid in month 9. Mary also is going to become eligible for Medicaid in month 9, and her shortfall on a monthly basis was $450 each month. The advantages of doing this type of planning is that we were able to make an immediate gift or wealth transfer of around $171,000, which, like I talked about, is more than 50% of the total assets. and Medicaid is going to start paying for Robert and Mary's care in month 9. The potential disadvantages of this type of planning is that if Robert and Mary do not live through the 8-month penalty period or private pay period, they really have not experienced any economic benefit from Medicaid, because Medicaid is not going to start paying until month 9 after the private pay period has expired. So with all of these cases, life expectancy is going to be a factor in whether we anticipate the couple to survive through the term of the penalty period. The annuity parties for Robert's annuity, Robert is going to be the annuity owner, the annuitant, and the payee. The primary beneficiary is likely going to be the state Medicaid agency, to the extent that Medicaid benefits are provided on behalf of Robert. The contingent beneficiary or secondary beneficiary can be anybody that Robert chooses to receive the remaining annuity amount. So this can be the couple's children, a trust, a charity, or Robert's estate, whoever they want to name as a secondary beneficiary. There are a couple of exceptions to the state Medicaid agency being listed as the primary beneficiary, and in this case, the only relevant exceptions would be if the couple has a minor or disabled child that could be listed as the primary beneficiary before the state. Mary's annuity is going to be set up the same way, where she is going to be the annuity owner, the annuitant, and the payee. The state Medicaid agency is going to be the primary beneficiary to the extent that they would provide benefits on behalf of Mary. And the secondary or contingent beneficiary is going to be children, a trust, a charity, or whoever Mary would want to name as a secondary beneficiary. If we assume that Robert passes away 6 months after his 8-month annuity is purchased, we would be asking what is going to happen to the Medicaid compliant annuity. And in this case, since the state Medicaid agency is likely going to be the primary beneficiary to the extent that Medicaid benefits are provided, the state is not going to have a claim against the annuity based on the fact that they're using that annuity income to privately pay during the penalty period. So we would likely receive a clearance letter from the state that indicates that they did not provide any Medicaid benefits to Robert during that time frame. Assuming he lists the couple's children as the secondary beneficiaries, the children are going to receive the remaining annuity amount for that 2 months that would be left in the annuity contract. Some states are going to add that remaining 2 months of penalty to Mary's penalty period. If you recall, Robert's annuity and his penalty period, it was going to be an 8-month time frame. If Robert passes away 6 months into his private pay period, some states are going to add that remaining 2 months of penalty to Mary's penalty period because she is the surviving spouse. Therefore, the secondary beneficiaries of Robert's annuity should be aware that they may need to use some of the annuity proceeds from his annuity in order to cover the private pay period of the additional 2 months of penalty for Mary. When Robert passes away during the term of the annuity, we talked about that Mary's initial penalty period was an 8-month time frame. If the state would add an additional 2 months of penalty onto her existing penalty period, that is going to create a 10-month time frame, but the annuity is still only going to pay out for an 8-month term. So with Mary's annuity being set at an 8-month term, assuming there would be 2 months of additional penalty, that may need to be covered by the gifties in order to get through that additional 2 months of penalty. If we assume that Robert passes away 12 months after the annuity is purchased, nothing is going to happen to the annuity contract in this case because Robert's annuity was structured for an 8-month time frame and it would be done paying out after 8 months. So Robert passing away 12 months after the annuity is purchased is not going to have any impact on the annuity contract because Robert would have already been on Medicaid for a 4-month time frame in that case, and the state being listed as a beneficiary is not going to be relevant. The time frame for setting up a gift and annuity for a married couple is generally going to first involve making the gift, purchasing both annuities, one for each spouse based on their income needs, and then applying for Medicaid. This usually is going to occur all in the same month so that Medicaid considers the clients to be otherwise eligible for Medicaid. Medicaid is going to provide a determination letter that outlines what the private pay or penalty period would be as a result of making the gift. And then the clients are going to use the annuity income that is set up in order to privately pay during the penalty period or the private pay period. After the private pay period is over, the clients are going to be Medicaid eligible after that penalty period. And so the penalty period and the annuity time frame are going to match up so that when the penalty period expires, the annuity period is also going to expire. The plan is going to change slightly if clients reside in an income cap state. So like we talked about initially, an income cap state is the state that imposes a limit on the Medicaid applicant's total income. The current income cap amount for 2021 is $2,382 per month in most states. In this case, the gift and annuity strategy is not going to change at all. However, the income that is over the cap amount is going to have to flow through a Miller Trust or a qualified income trust before paying the nursing home. You recall that Robert and Mary's total income in this case was over $9,000 per month. So that definitely exceeds what the cap amount is at $2,382. So they're going to first have the annuity payments flow through the Miller Trust before the nursing home bill is paid on a monthly basis at $10,000 per month. On the screen here, you're seeing all the states in orange that are currently considered to be income cap states. And so if you reside in these states, you would need to set up a Miller Trust in order for these clients to meet the income limitation in your state. Two alternatives to doing a gift and annuity strategy for a married couple that both spouses are applying for Medicaid at the same time would involve a gift and promissory note plan. Likely the promissory note would be set up for each spouse, similar to the annuity. And a second alternative to the gift and annuity strategy would be to do a gift in return or a gift in partial cure. If we assume that there's a fact change and the timing of each spouse needing care is slightly different than our initial example, we would want to take into consideration how the plan would change if one spouse is already on Medicaid and the second spouse later needs care and makes a gift and would be applying for Medicaid after the first spouse is already on Medicaid. This is going to depend on each individual state as far as how the penalty period would be dealt with if one spouse is already on Medicaid and the second spouse ultimately would make a gift and need to apply for care. So some states are only going to apply the penalty period to the second spouse that has made the gift and would need care second, which would mean that there would only need to be one annuity that is purchased, because the penalty period is only going to apply to the second spouse. The first spouse would remain on Medicaid uninterrupted, whereas most states are going to apply the penalty period to both spouses, and the plan is going to look very similar to what we talked about today. So in other words, the second spouse making a gift is going to result in a penalty period applying to the first spouse that's already on Medicaid. In that case, we would need to have two annuities purchased, because the penalty period would be split equally between the two spouses, and the second spouse would need a source of income to be able to cover their cost of care during that private pay period. Generally, we're going to look for language in each state Medicaid manual. This is sample language that you're seeing in Michigan's manual that talks about splitting the penalty period equally between each spouse, and what happens if one spouse is already on Medicaid and how they're going to deal with the penalty period for each spouse. So I would encourage you to look in your manual to find out if you have a situation where one spouse is already on Medicaid and the second spouse is going to later apply for benefits. So in summary, the timing of the plan is going to really dictate whether we're doing an annuity for one spouse or both spouses. Generally, like we talked about, if both spouses are applying for Medicaid at the same time, then the penalty period is going to be split equally, and each spouse is going to need to purchase an annuity or do a promissory note in order to meet the income and asset requirements that would be required of each individual. Also, we want to consider the couple's longevity. If one spouse is not anticipated to survive during that penalty period and they pass away, then we need to be aware that the state may add that additional penalty to the surviving spouse's penalty period. And it does look like I have some questions here that people are asking. Somebody is asking about, where do I find Illinois' divestment penalty divisor? Illinois actually uses the cost of care of the specific facility that the client is in. So if the client is paying $300 a day for their care, that is what Illinois is going to consider to be the divestment penalty divisor for that client. So it completely depends on the cost of care of that specific facility. Somebody is asking whether this strategy will work in Oregon. That is going to likely not. The reason why is that Oregon has an actuarially sound requirement for annuities, which basically dictates that the annuity has to be within 12 months of the person's Medicaid life expectancy. In a case like this, because we're likely going to do the annuity for such a short period of time, unless the client is very old and their life expectancy is within the time frame of meets the actuarially sound requirement, we're likely not going to be able to use this type of strategy in Oregon, Washington, or North Dakota is the third state that has actuarially sound requirement. Somebody is asking about how is the shortfall during the annuity payout period paid? And does Medicaid get the shortfall if Robert passes away during that time frame? So the shortfall is generally going to be paid either from the individual resource allowance that the couple would keep, the $2,000 that they have in each of their names. Otherwise, the additional shortfall would need to be covered by the giftees. Okay, yeah, there's additional state-specific questions here as well. I will reach out to people individually to answer the state-specific questions. But if anybody else has some general non-state specific ones, I can. Somebody is asking about if we use the gifting strategy and purchase the annuities, do we not need to worry about the 5-year look back period? So we are taking into consideration the fact that Medicaid does currently have a 5-year look back period for any transfers or gifts that are made, and we would be, in this case, agreeing to privately pay for an 8-month time frame based on the couple gifting around 171,000 of assets. And so if we wanted to be completely outside of the 5-year look back period, the clients would have had to do pre-planning and start transferring assets 5 years earlier. But in this case, the gift and annuity strategy is the best way to, or one of the ways to preserve at least some of the assets and agree to privately pay during that 8-month time frame that would be associated to gifting money. Okay, and the rest of these are state-specific questions, but I want to thank everybody for joining me today. If you have any other questions, feel free to reach out to me either by phone or email. My phone is listed here on the slide as well as my email. And I look forward to March's webinar where we're going to be talking about how we can help with the actual funding of annuities and the different types of services that we offer. Sorry, I just got some more questions here. Okay, I will reach out to individuals directly about the questions that were just posted here. Thank you all for joining me and have a great day. Take care.